The Honourable Minister Chester Burrows.
Thank you, Mr Chair, and I'd like to congratulate the way the committee and speakers have engaged in this debate in moving the bill through the process of the Select Committee, and comments made earlier by the Honourable Phil Goff which indicated that both sides of the House, and he singled out the Honourable Kate Wilkinson as somebody who had been part of it. So it's great to see that sort of cross-house debate. I guess much as I endorse fully the comments of the previous speaker, the Honourable Marion Street, I think it's important to acknowledge that there is a whole swathe of victims here who won't be covered by this legislation. What we know is that only about 1 in 10, and I would sort of tag on to the back of that, 1 in 10 female rape victims report a rape. And what we know is that only about 33% of all rapes taken to court actually result in a conviction. So if we accept those rules of thumb, and I think we're probably being generous in the amount being reported, only about 0.3 of those people who are victims of rape, those females victims of rape, will actually be covered by this piece of legislation. So the challenge before this House is actually to have a reporting system, an investigation system, a prosecution system, a sentencing system that actually encourages people to report crime. And specifically these matters which very rarely get reported. And it would be interesting to know, and I don't know of any work that's been done on it, of how many rape victims who, having reported the rape against them to the police, having gone through this process, actually would ever go on to report a second rape. Because I know a lot of rape victims, and I can't think of any who, having been through the process, said that they would go through the process a second time. And I want to just also explain to the House, or acknowledge, the hell of a long way we've come in respect of the investigation, the reporting and so forth of rape crime. When I first became a detective and I was operating under the old detectives manual, the House would be absolutely astonished at the advice it gave to young detectives in those days about being very suspicious about females who complain of rape, and they largely put themselves in a position where it's brought upon them by the clothing they wear or where they are late at night and all those sorts of things. And that wasn't rewritten until 1985. Prior to 1985, it wasn't an offence to rape your wife, for instance. Prior to 1985, what we would call rape with an implement was only an indecent assault and didn't even amount to a sexual violation. That offence only came into force in 1985. And I remember investigating a rape in Nelson in about 1980, I guess, and this goes back to the comment made by the Honourable Phil Goff, and thankfully I don't think this would ever happen today. Two young men had given a ride home to a girl from a party. She was the worst for alcohol, and probably so were they. They drove her up the Maitai Valley. They both raped her twice. And I remember the case well because I got in trouble for unlawful detention and made a bit of case law if you ever want to go and have a look at it. But in any event, we arrested the two. One of them got 3 years imprisonment for rape, and one of them got 9 months periodic detention for rape. So, thankfully we now see that there pretty much a minimum tariff for rape is about 8 years and a 20-year maximum. And so I don't think you would ever find somebody convicted of rape getting a 2-year sentence these days, let alone a 5-year sentence, but I would like to think so in any event. So I just acknowledge that it was important to move that threshold down to 2 years, and also the changes that were made, that the application can be made on sentence or any time after sentence rather than release, is important. But again, just to acknowledge, there are a whole lot of victims here who won't be captured by this because there wasn't a conviction, there wasn't even a report, and in male rape I suggest that the figures are even less than 1 in 10. It is important that the protection was extended to surrogates because people who are involved in family violence, crimes against family members, and then particularly sexual crimes, Mr Chair, Sorry.
The Honourable Minister, Chester
Mr.
Burrows.
Chair, are in a class of people who are very good at manipulation, and they're also very good at getting people to do things for them, and that would include using surrogates to contact victims. Now, there were a couple of points that were raised by the Honourable Phil Goff. One of them related to, was there going to be a filing fee with respect of this, and I can assure the House that the District Court Fees Regulations 2009 will be amended to ensure that there is no filing fee. And what does filing entail? Filing entails filling in a form, similar to what we do now in application for a protection order. Most people would be able to do it without legal advice. If there was a need for legal advice, an application for legal aid could be made in any particular way, but I would suggest that people, friends and supporters of a victim, agencies such as Women's Refuge or Victim Support or the police themselves would be in a position to be able to assist anybody filling in the forms, which would amount to making an application under this legislation. So legal aid could be available if that was required in the normal circumstances. In any event, making or filing an application amounts to completing a form, and I know that some forms can be relatively complicated, but I also am sure that those people who need to fill in that form would be able to do so with the assistance of the agencies charged to do that, their friends or supporters, or the people who are behind the court counter ready to receive the application. The point was made by the member Raymond Ho that are these services available around the country, and whether or not, for instance, the police would be able to access an order once it was made. The way in which the police are currently resourced, particularly electronically, would mean that a simple check on the name of either the offender or the victim would easily be able to identify whether or not there was such an order in place. So I just want to reassure the House, given the comments and the questions that were raised, that I believe that the bill goes a long way towards settling a number of... Oh, sorry, an aside was made just by the member about the resources of Women's Refuge. We have to... I understand the challenges of resourcing these social agencies, but in the end we're talking about filling in a form, and I don't think that that would suck up a whole lot of resource from an agency charged and taking on the vocation of helping those in support of need vulnerable people. So I will leave it there, but I hope that I've covered the questions outlined by those.
I call the Honourable Member Jan Logie. Tēnā koe, Ms Logie.
Tēnā koe, Mr Chair.